If you've been searching Living Trust Alabama, you've probably run into a dozen different answers. I know because people tell me all the time they're confused. Some of those are contradicting one another. Surprise, surprise. So let's clear it up. I'm Tanya Hendrix. I'm an estate planning attorney here in Huntsville, Alabama. And in the next few minutes, I'm going to tell you exactly what a living trust is, whether Alabama even requires one, and how to know if it's the right tool for your family. So this video is for you if you own a home, you've got minor children, you've got some savings or investments, you're concerned about family dynamics, what's going to happen after you pass away, and you've heard that maybe a trust can help your family avoid probate. But nobody's actually explained what that means. Not in plain English, and I can speak it, I promise. That's what I'm doing today. A living trust, sometimes called a revocable living trust, is a legal document you create while you're still living and competent that holds title to your property. So instead of your house or your bank accounts or investments being owned by you as an individual, they're owned by the trust. You're still in control. As long as it's a revocable living trust, you are still in control. You're typically the trustee, meaning you manage everything exactly like you do now. You can buy, sell, spend, or change the trust at any time while you're living and of sound mind. Now, the key word here is revocable. It's not locked in stone. Think of it less like giving away your property and more like putting it into a folder with your name on it, except that folder has instructions built in for what happens if you become incapacitated and what happens when you pass away. Here's where it gets Alabama specific. Alabama's probate process isn't the most burdensome in the country, but it's also not quick or private. So when someone dies owning property in their own name, that property typically has to go through probate before it can be transferred to others. So even if you have a will that says where the property goes, if you die in Alabama, you have property in your name at the time of your death, it will have to go through probate in order to transfer to whoever you named in the will. So in Alabama, that probate process typically takes several months to years. It can involve, and it will involve some court filings that become public record. Everything in probate courts, as far as your estate, is public. And if you own property in more than one state, that may require a separate probate proceeding in the other state or every other state you have property in. It's called an ancillary probate. So a living trust avoids that because the trust, not you personally, owns the property. There's nothing that needs to pass through probate when you die. Your successor trustee, the person that you're going to name when you prepare your trust document, simply distributes the trust assets according to your instructions. There's no court filings, there's no public record, no months-long waiting for your family. The trustee can go ahead and transfer to whoever you have designated in the trust. And there's a second reason that people in Alabama set these trusts up, and it often matters just as much. Incapacity planning. If you become unable to manage your affairs, say maybe you have a stroke or you get a dementia diagnosis, your successor trustee can step in immediately and manage the trust property without needing a court to appoint a guardian or conservator. That's a level of protection that a basic will simply does not give, because a will only takes effect after your death. Now, I get this question constantly, so I want to be very direct about it. A will is a set of instructions that only activates at death. And in Alabama, a will has to go through probate to be carried out. So just because you have a will does not mean you avoid probate. A living trust operates the moment you sign it, and you've got to fund it. And it continues operating through incapacity and after death without the need for probate. Now, that being said, almost everyone with a living trust in Alabama still needs a will. It's called a pour-over will, P-O-U-R, pour. It's a backup document. It catches anything that you forgot to title in the name of the trust and directs it into the trust when you pass away. So it's not really an either or. It's not, do I need a will or do I need a trust? If I have a trust, do I need a will? They work together. And I personally, as an estate planning attorney in Huntsville, will not do a trust without a will because they have to work together. And there has to be a catch-all if you forget to put something in the name of the trust. Now, another reason to have a trust is when you have minor children. If you have minor children, you can have a trust document where the trustee manages that property. Whatever, if you pass away while they're still young, the trustee can manage that property until whatever age you designate and still pay for their health, education, maintenance, and support until they reach whatever designated age that you want them to receive the big payout. So having a trust is really a necessity when you have minor children. Now, here's one of the biggest things and biggest mistakes I see people make when they have a trust. They sign this beautiful, lengthy trust document and then never actually transfer property into it. If your house is still deeded in your individual name, or if you have a bank account that's still in your individual name, or you have not named the trust as the payable on death beneficiary, that property is not protected by the trust. No matter how well the document is written, no matter who did the document, no matter how much money you paid for it, you must fund it. This step is called funding the trust. And what it basically means is retitling your assets, retitling your real estate. So your house, your lake house, your other land that you have. You have to retitle it into the name of the trust. Updating account ownership if you want to have a trust account, or you can name the trust as the payable on death beneficiary. A trust that isn't funded is basically an empty folder. This is the step that actually makes it work. A trust is only as good as what's in it. If you want the trust to manage and distribute something after your death or while you're incapacitated, it must be in the trust. Not everyone in Alabama needs a living trust. If your estate is simple, your assets are modest, or you're comfortable with your family going through probate, a well-drafted will may be all you need. But if you own real estate, especially in more than one state, if you have minor children, if privacy matters to you, if you want to avoid a court-supervised guardianship in the event of incapacity, or you simply want your family to have the smoothest possible transition, a living trust is usually worth the investment. If you're not sure which category you fall into, that's exactly the kind of question we sit down and answer during a consultation. I'm Tanya Hendrix, Huntsville Estate Planning Lawyer, LLC, and you can find the link to schedule a description below, or a call in the description below, or call me directly at 256-361-1221. And I'll be happy to sit down with you and talk with you and determine if a living trust is right for your family in your situation. Because with all of the confusion out there about living trust, you really only get the right answers when you talk to an attorney experienced with trust about your particular situation, about your family, and what's best for your family and those who you love. Again, I'm Tanya Hendrix, Huntsville Estate Planning Lawyer.